Dean Underwood speaking. If you've logged on for the latest in Cornerstone Barristers webinar series, this one on licensing the private rented sector, prosecutions and financial penalties, top tips for successful enforcement, you're in the right place. Don't go anywhere. We've got more than 200 registered for this particular webinar. So I'm going to give them a minute or two just to log on this morning to make sure they've got their cup of coffee, like me, and I'll be back online and we'll start the webinar at 1 or 2 minutes past 11. So sit tight and I'll be back with you shortly. Well, good morning, everybody, and welcome to the latest in Cornerstone Barristers series of webinars for 2022. This one, licensing the private rented sector, prosecutions and financial penalties, top tips for successful enforcement. And this, as many of you will know, is the fourth in my series of webinars, a series of 4 webinars through July, focusing particularly on licensing the private rented sector. So what can you expect from today's webinar? Well, again, as many of you will know, the Housing Act 2004 creates a number of licensing offences and it enacts a suite of provisions designed to enable local housing authorities to investigate and enforce the Act's licensing schemes effectively, as they're required to do under the 2004 Act. Some of those provisions concern entering and inspecting premises under, for example, sections 239 and 240, obtaining information for the purposes of exercising their functions under parts 2 and 3 of the 2004 Act, under, for example, section 235, applying for and assisting with applications for rent repayment orders under either the 2004 Act if you're in Wales or the Housing and Planning Act 2016 in England, imposing financial penalties for licensing and other offences under section 249A, and prosecuting licensing offences under parts 2 and 3, in particular sections 72 and 95 of the 2004 Act. Now, in the time available to us today, we won't possibly be able to look at all of those provisions. So the focus of today's webinar will be on an overview of the offences that are created by the 2004 Act and the means of enforcing them. So we'll take a look at those in summary. An overview of local authorities' key investigative powers. How do they go about actually collating and obtaining the evidence in order to be able to penalise or prosecute. Then we'll have a look at key aspects of prosecuting licensing offences, such as the threshold test for bringing a prosecution and limitation. And then most of our time today, I imagine, will be spent on financial penalties. I'm likely to say most about those, and indeed most of the questions that we've received in advance of today's webinar have been about financial penalties. As ever, any views expressed today are for educational purposes only and not advisory. So if you require legal advice about a particular issue, please get back in touch and I'll be happy to assist you. There will be a feedback form coming out from us at the end of today's webinar. These are really important for us in being able to tailor and shape webinars for the future, and knowing how effective this series of webinars has been. So please take the time, only a few moments, to fill that in and return it. Any questions? As usual, you have my email address. So, enforcement in overview. The 2004 Act creates several offences that are really key to the effective enforcement of licensing under the 2004 Act. So having control of or managing an unlicensed HMO or house, for example, under sections 72 and 95, knowingly permitting a Part 2 HMO to become occupied, essentially overcrowded, occupied by more persons or households than is authorised by the licence, failing to comply with licence conditions, and failing to comply with HMO management regulations under section 243. Now, the latter, I appreciate, is strictly not a licensing offence. It will apply to HMOs whether they are licensable or not, but it has many features in common with licensing offences and complements the suite of licensing enforcement provisions under parts 2 and 3. Now, a few points to note about these offences. Most of them are strict liability offences, as we'll see in a moment. So the defences to them are limited. For example, a reasonable excuse under section 72.5 or 95.4, and indeed under section 234, or for example, having a duly made and outstanding licence application before the local authority. Further to that, having there being a temporary exemption notice being enforced. But as I say, the defences are limited. The means of enforcing the 2004 Act's provisions have grown in recent years, since 2016 in particular, both in number and in scope. So they include, for example, prosecution, at which we'll look later on, financial penalties of up to £30,000 for each offence, rent repayment orders in the first tier tribunal, banning orders under the Housing and Planning Act 2016, entry on the rogue landlord database in the event of conviction, for example, revocation of a licence, at which we've already looked in one of the webinars in this series, and restrictions on tenancy termination in the case of assured short-term tenancies. So as you'll note from that list, the range of those powers has increased significantly since 2016, when one can infer, certainly from the legislation, that the government decided to take a more robust approach to enforcing the 2004 Act's provisions. Now, where do we learn that the licensing and management offences are strict liability offences? Well, in the first place, in the case of Mohammed and Waltham Forest London Borough Council, one of my cases, which I did with Simon Keeley of Sharp Pritchard and David Beach at Waltham Forest, and in this particular case in the Divisional Court was led by Ashley Underwood, no relation, although allegedly the tests are still being done. And I won't take you through the facts of the case, but in short, the argument before the Divisional Court was whether the Section 72.1 offence of managing or having control of an unlicensed HMO required the authority to prove what we lawyers call mens rea, a mental element to the offence, so that the person either did it intentionally or knowingly. And the conclusion of the court very clearly in that case was no mens rea was part of the offence. It was a strict liability offence, and mens rea came into account when a defence of reasonable excuse was raised by a defendant. So strict liability offence for section 72.1, and by analogy, therefore, for section 95.1 as well, which of course creates the corresponding offence in respect of Part 3 houses. And then in respect of the management regulations, we find the proposition, authority for the proposition in IR Management Services in Salford City Council. And in this case, the argument before this case, the upper tribunal, was that a necessary element of the offence under section 234, subsection 3, was that the local authority had to prove that the penalty recipient did not have a reasonable excuse for the offence. And the upper tribunal, perhaps unsurprisingly, said no, that's not the case. It's a strict liability offence. If the penalty recipient wishes to raise a reasonable excuse defence, then the onus is on him or her to do so, and the burden is on him or her to discharge, to prove that reasonable excuse, albeit not to the criminal standards, but to the civil standard of proof. So that's where we find authority for those two propositions. So that was just a brief overview for you of the key enforcement provisions and a few words about their nature and their scope. So with that context in mind, let's take a look now at some of the authority's key investigative powers. And these really are essential for the successful enforcement of licensing provisions. So, as you will see, and perhaps not surprisingly, there are a range of investigative powers that are enacted, not just by the 2004 Act, but actually by rather older legislation, such as Section 16 of the Local Government Miscellaneous Provisions Act 1976. Now, I'm just going to invite you to take a look at this slide and absorb some of its content, because I'm going to switch my screen in a moment to the legislative provisions themselves, so you can take a look at them as we speak about them. So if I switch my screen now, I'll take you first of all to the Local Government Miscellaneous Provisions Act 1976, and you should have now on your screen Section 16. And in short, this is a power which enables local housing authorities, local authorities generally, to obtain information about a person's interest in property. So as you'll see, and I've highlighted the key provisions, the authority may serve on one or more of the following persons: that the occupier of land, freeholder, mortgagee, lessee, or someone who directly receives rent or indirectly does so, and any person authorized to manage the land or arrange for its letting. So the authority may serve on them a notice requiring the recipient to furnish the authority with information about the nature of his interest in the land, the name and address of each person whom the recipient believes is the occupier of the land. And there is, as you will see, an offence for failing to comply with the requirements of that particular section. So that is a section which is designed to enable local authorities to obtain key details about ownership and occupation of land. It doesn't necessarily, as far as I'm aware, or stand corrected, enable the authority to obtain documents. But the local housing authorities are not deprived of any power in that regard, particularly under the 2004 Act. So if I now take you to the 2004 Act, and bear with me, I'll find you the relevant provisions. Section 235 is the provision we will look at first, because Section 235 enables local housing authorities to serve on various persons a notice not dissimilar to that under Section 16 of the 1976 Act, but which enables the authority to actually obtain documents. Again, I've highlighted the relevant parts, and you should have Section 235 on your screens. So it enables the authority to serve a notice requiring documents that are reasonably required by the authority, and note these particular provisions, for any purpose connected with the exercise of any of its functions under parts 1 to 4, so therefore inclusive of licensing under parts 2 and 3, or for the purpose of investigating whether any offence has been committed under any of those parts 1 to 4. So a person who is authorised in the way that is specified in the section to serve such a notice may give notice to a relevant person requiring him to produce any documents specified in the notice and that are in his custody or control, and to produce them at a time and a place specified by the authority. To my mind, the importance of this particular provision is not to be underestimated. It's a very important power in the local authority's investigative armory, because it not only empowers local housing authorities to obtain, for example, lease or tenancy or management agreements, but importantly, other documents such as inspection logs or safety certificates, and indeed statements of rent accounts and other documents that are required to establish who has control and who is managing the premises. And on the face of it, and I'm not aware of any case law to the contrary, it's wide enough to enable the authority in an appropriate case to request, for example, bank statements which demonstrate the transfer of monies from one person to another, for example, from a managing agent to the person having control of the property. So as I say, this is a key provision in the investigative armory that really enables the local authority within a short period of time to be able to establish evidence for key elements of the licensing offences, such as having control and managing premises, both of which relate, of course, to the receipt of rent. In addition to that power, and you'll note if I just take you through these provisions, Section 236, there is a related offence of failing to comply with the requirements of such a notice. So it's a provision which has teeth. But also, of course, under Section 237, local housing authorities have power at their disposal to use information that they've obtained essentially for the purposes of housing benefit and council tax, to use that information for the purposes of exercising their functions under parts 2 and 3, and indeed parts 1 and 4 as well, and for investigating whether an offence under those parts has been committed. So you are, of course, then entitled to look at your relevant housing benefit and council tax records when assessing, for example, who has control of the premises. And then last but not least, important powers, and I'll brush over Section 238. We touched upon it, I think, in the last webinar, but that, of course, enables local housing authorities to enforce provisions requiring the provision of information. So if somebody knowingly provides the local authority with false information or misleading information, or is reckless as to whether that information is false or misleading, then they can be prosecuted under Section 238. But under Section 239, the local housing authority has two key powers of entry. First of all, under subsections 1 and 3, for the purpose of, and I've highlighted the relevant parts for today's purposes, for the purposes of determining whether any functions under parts 1 to 4 or indeed part 7 should be exercised in relation to the premises. So part 7 includes, of course, Section 249A, which is imposing penalties. And where the local authority is satisfied that a survey or examination of a property is required for that purpose, then it has the power to enter premises, albeit on notice to the occupier and the owner. But where the purpose is investigating whether an offence has been committed under sections 72, 95, or 234, then the authority is empowered to enter the premises without giving notice and at any reasonable time. So another key provision in the local housing authority's investigative armory, and very much like the provision under section 235, is given teeth, in this case in section 240, by the local authority being able to apply for a warrant in the event that entry is refused. So the magistrates can, in the circumstances prescribed there, make a warrant, grant a warrant of entry. And in section 241, which creates an offence of obstructing a person in the performance of anything which by virtue of parts 1 to 4 they're required or authorised to do. So obstructing an officer in the exercise of their functions becomes an offence. So these are the key investigative powers of local housing authorities. I'll probably come back to section 235 in particular in due course, because as I say, that really is a key provision in quickly and efficiently enabling local housing authorities to gather the information needed to either prosecute or penalise. Well, let's move on now, and I'll shift my screen back for you to the slides. Let's move on to prosecutions. And we'll cover some of the key concepts, key aspects of prosecuting, but we're not going to look at it in as much detail as we will financial penalties in a moment. So some key facts about prosecutions under the 2004 Act. So as we've discussed already, the key licensing and HMO management offences under sections 72, 95 and 234 are indeed strict liability offences, and I'll take you through what we looked, in fact, briefly a moment ago at Mohammed and IR management services. And it's worth noting as well that the licensing offences are also continuing offences. What does this mean for local housing authorities? There is, as we discussed previously, no need to prove mens rea, so a mental element to the offence, and the burden is therefore on the defendant or the person being penalised to establish any reasonable excuse or other defence to the civil standard of proof. And indeed, because they are continuing offences, and I refer specifically to the licensing offences only in that regard, I don't think it's quite been established yet that the offence under section 234 is necessarily a continuing offence. But because the licensing offences are continuing, then time to penalise or prosecute for them will continue to run, for example, until a licensing application is made or the requirement to license the property ceases. And we'll come back to that a little bit later on. By contrast, the offence of overcrowding a licensed HMO does require proof of mens rea. So essentially, it's that the person managing or having control of the licensed HMO knowingly permits another to occupy it such that it becomes occupied by more than the number of persons or households that is authorised under the licence. All of the offences under sections 72, 95, 234 are enforceable in the Magistrates' Court and in the Magistrates' Court only, and on summary conviction, they're all punishable now by an unlimited fine. So as I say, that was changed in recent years because of the more robust approach that the government decided to take to what they call road landlords. Importantly, however, and we'll look at this in a moment, time to investigate an offence and lay in information before the Magistrates' Court is limited by section 127 of the Magistrates' Courts Act. Decisions to prosecute have to be taken in accordance with the Code for Crown Prosecutors, and we will also look at that briefly in a moment. But importantly, and this is where prosecutions differ considerably and significantly from proceedings before the first-tier tribunal on a penalty appeal, criminal procedure rules apply. Presently, they are to be found particularly in the Criminal Procedure Rules 2020. So there are, as a result, restrictions on the use, for example, of hearsay evidence and on the use of bad character evidence. For example, evidence which is designed to show an offender's propensity to commit a particular offence. And applications will therefore need to be made to the Magistrates' Court for permission to adduce that evidence or to demonstrate that an exception to the general rule that that evidence is not admissible applies. And again, I'll return to that. Again, a significant difference between prosecutions and penalty proceedings is that generally in the magistrates' courts, if you are successful in convicting a defendant, then costs will be recoverable and can be enforced against the defendant, so that you can recover your legal costs. And if the prosecution fails, the local authority does not itself pay out the defendant's costs. Instead, those costs are payable from central funds. So in that respect, there is some protection for local authorities who bring prosecutions from cost liability. Let's take a look now at a very important concept of limitation. And as I mentioned, this is enacted by section, for the purposes of prosecuting, under section 127 of the Magistrates' Courts Act 1980. And I've set it out there because it's important in subsection 1 in full. So except as otherwise expressly provided by any enactment and subject to subsection 2, which I've not set out, a magistrate's court shall not try an information or hear a complaint unless the information was laid or the complaint made within 6 months from the time when the offence was committed or the matter of complaint arose. So we will compare and contrast that in due course with the provisions that relate, the limitation provisions that relate to financial penalties, because they are materially different and this is materially stricter. Time runs within 6 months from the time when the offence was committed, not from when the authority has sufficient evidence that the offence was committed. So note that limitation will begin to run in respect of the key licensing offences, that is essentially, if I can put it this way, failing to license an HMO or house. So it will begin to run if the HMO or house ceases to be an HMO or house to which Part 2, or as the case may be, Part 3 applies. For example, because a designation comes to an end, or because the owner takes up occupation of it and it's no longer let. Or, for example, if the HMO or house no longer requires a license for some other reason, whether that be, for example, a temporary exemption notice is in force, or a temporary exemption notice is in force, or indeed an application to license the property has been duly made, a concept on which we touched last week, because in those circumstances, if the application is made and certainly not determined, then time will begin to run. So that is a key provision and a key limitation on which local authorities have to keep their eye if they are considering prosecuting, because it is a strict time limit and runs from when the offence is committed. Now, importantly, for offences under sections 72 and 95(1), as we've seen, because they are continuing offences, then the 6-month period will continue to roll so long as that offence is continuing. But as I say, once that offence ceases for any of the reasons set out on the slide or other reasons, then that 6-month period will start to expire. So deciding to prosecute. In short, local housing authorities are required to consult and apply the Code for Crown Prosecutors in the same way that the CPS does. And there is a 2-stage test, essentially, for establishing whether to prosecute or not. It's called the full code test, and it has 2 parts, the evidential stage and the public interest stage. The evidential stage provides that prosecutors be satisfied there's sufficient evidence to provide a realistic prospect of conviction against each suspect on the charge. And that requires the local housing authority to consider proactively and in advance what defence might be raised by a defendant and how that is likely to affect the merits of a prosecution. So, for example, if you take the view that a defence is very likely to succeed, then you might take the view that prosecution does not pass the evidential stage of the test. If it doesn't pass that stage, then the prosecution must not proceed, no matter how serious or sensitive the case may be. If it does, however, pass the evidential stage, then local authorities are also required to consider the public interest test, the public interest stage, and in every case where there's sufficient evidence to justify prosecution or to offer an out-of-court disposal, prosecutors must go on to consider whether a prosecution is required in the public interest. And but the public interest generally requires consideration of various factors, including how serious the offence is. The more serious it is, then the greater the public interest in prosecuting. The defendant's culpability, the more culpable they are, again, the greater the public interest. The harm that has been caused, not just to, for example, in this particular context, the occupants of a house or HMO, but to the community, and the community impact is a relevant consideration. Local authorities, like other prosecutors, must look at the defendant's age and maturity, and that weighs in the balance. And then look at, lastly, unsurprisingly perhaps, proportionality. Is prosecuting a proportionate response to the offending behaviour? And that comes into play, especially because there is, of course, now an alternative to prosecuting, which is penalising instead. And a local authority may take the view that imposing a financial penalty is perhaps a more proportionate way of addressing the offending behaviour. But that is a key stage in your investigative and pre-enforcement decision-making, looking at the Code for Crown Prosecutors. What about sentencing? Well, there is not a great deal of assistance to be derived from either case law or indeed sentencing guidelines when it comes to sentencing. And I know this is a bit of a bugbear for many of the local authorities who are online this morning, because there is no sentencing guideline that is specific to 2004 Act licensing offences. So courts will generally follow the general sentencing guideline. And if you'll bear with me, I will switch my screen so that we can see that in overview. So the general guideline requires the court to take essentially a 10-stage approach to sentencing. Not all of those stages or steps in the process will be relevant in the case of the regulatory offences under sections 72, 95 and 234. But briefly, as you'll see from the right-hand side of the screen, step 1 requires the court to reach a provisional sentence. And that requires the court to assess the seriousness of the offence by reference to the defendant's culpability and harm, the culpability and the harm that's caused, rather, and then to reach a provisional sentence, taking account of a number of factors, including the statutory maximum, any relevant Court of Appeal judgments, such as Sutton and Norwich City Council, which concerned the circumstances or the care that has to be taken when imposing, in that case, a penalty on both a company and its sole director to avoid the prospect of double punishment. Same principles apply in the context of prosecution. And then also take a look at any definitive sentencing guidelines for analogous offences. I'm not aware of any, although I think some reference has been made in the past to sentencing principles for offences under the Environmental Protection Act 1990. I'm not so sure of the relevance of that. But I do think that in appropriate cases, it's good to remind the court of the local authority's own enforcement policy, of its penalties matrix and guidance, so that there is some consistency in approach, and indeed also of the guidance that is given in respect of financial penalties, in which the government emphasises that the courts, that the first-tier tribunal local authorities are required and expected to take a robust approach to enforcement. Step 2, identify any relevant aggravating and mitigating factors and whether they should result in an upward or downward adjustment. And it's often helpful for the court and indeed the parties for the prosecuting authority to set out in a schedule form the aggravating and mitigating features. Then consider any factors which may warrant a reduction for assisting the prosecution. Doesn't often happen in these types of prosecutions. Then the court's required to take account of any potential reduction in the sentence for a guilty plea. For that, you need to take a look at the reduction in sentence for a guilty plea guideline, which gives guidance on the amount of the reduction and the circumstances in which it should apply. Steps 5 and 6 concern prescribed dangerous offences and offenders of particular concern, and they are really not relevant to these regulatory offences. But then step 7 takes us to totality. So if sentencing for more than one offence, the court's required to consider whether the total sentence is just and proportionate to the overall offending behaviour. At step 8, it needs to look at whether to make compensation or other ancillary orders, such as victim surcharge, which is required to order. Then it's required to give reasons for its sentence. And step 10, which requires consideration of time spent on bail, is not relevant. So that's the general approach. And I provided you, if we turn back to the slides, with just one example of fines that were imposed in the Mohammed case, again, which I say I was involved in, and I, after the divisional court case that we looked at earlier, returned to the magistrates' court for trial, and resulted, as you'll see, bottom right-hand corner, in fines of £126,500 for Mr. Mohammed and £60,500 for his wife, Shahara Lari. And because we're rather short on time, I'll leave you to consider the summary of that case when the slides are forwarded to you later. So, top tips for successful prosecution. And I'm conscious that we're already 25 to 12, so I'm going to have to be a little bit quicker. So ensure that there is sufficient evidence for to prove each element of the offence. And the one area that local housing authorities not uncommonly overlook is proving to the criminal standard of proof that the defendant either had control of or was managing a property. And that often requires a very careful tracing of not only the collection and receipt of rent, but actually its transfer on, especially where you have a managing agent acting on behalf of the person having control. So don't take for granted that the fact there is a management agreement in place, that you will therefore be able to establish that the managing agent must be passing that rent on to the freeholder or the leaseholder. Get the evidence to establish it. Keep an eye on limitation. Remember, it's a strict 6-month period from when the offending period ceases. In respect of controlling continuing offences, rather, and otherwise a strict 6-month period, full stop. Take care when you're settling the information. Make sure that you record the offence correctly, both in its statutory provisions and the facts that describe it. Provide the court with sufficient information to issue the summons. Take a look at the Clarn case for details about what the court generally requires. This is not usually a problem because local authorities tend to provide the court with a summary of the evidence supporting the offence committed. And I'd certainly recommend that course of action as a matter of good practice. Make sure you identify hearsay and bad character evidence at an early stage and make any necessary applications under the 2020 criminal procedure rules. Don't leave it until the day of trial because you will face applications to essentially strike out the evidence as being inadmissible. Do keep track of witnesses. They, especially occupiers of HMOs and houses, they move. Make sure you keep forwarding addresses for them, and if you consider that their attendance at the trial is likely to be unreliable, you can witness summons them and do so. Otherwise, you may find yourself caught short at court. Anticipate and prepare for the potential defences. And invite the court, importantly, to record the limits of those defences at an early case management stage of proceedings so that you and the court knows precisely what is in issue before the court. And don't forget a cost schedule, because if you are successful, you can, of course, recover your costs from the defendant. So financial penalties. Let's move from prosecution then to penalties under section 249 of the 249A of the Housing Act 2004. And some of these provisions, the content of these slides will be trite. What is a financial penalty? Well, it's a fine that is levied by a local housing authority in England on an individual or organisation as an alternative to prosecuting certain housing-related offences. the authority may, as you'll see from the fourth point on that slide, impose a penalty on a person if it is satisfied beyond reasonable doubt, i.e. to the criminal standard, that the person's conduct amounts to a prescribed offence in respect of premises in England. So this does apply in respect of essentially English premises, English local authorities. What are the key prescribed offences? Well, as you'd expect, they include the key licensing offences, as well as failing to comply with an improvement notice. As you'll see there, managing, having control of an unlicensed HMO, permitting the overcrowding of a licensed HMO, failing to comply with HMO licence conditions, the corresponding offences under Section 95 for Part 3, and then also failing to comply with an overcrowding notice and failing to comply with HMO management regulations. Sorry, I forgot to flip my slide there. So there you'll see the prescribed offences for which a penalty can be imposed. So local authorities are required before taking action to satisfy themselves that there'd be a realistic prospect of conviction. That is, proving the offence, the relevant prescribed offence, to the criminal standard of proof, if they were to prosecute it in the magistrates' court. So again, you need to look for that at the Code for Crown Prosecutors and establish whether the evidential stage, the evidential threshold, is met. You're also expected as local authorities to develop and document your own policies to determine whether to prosecute or whether to penalise. The policy, the government guidance, Civil Penalties under the Housing and Planning Act 2016, which you'll see referenced at the bottom of the slide, emphasises that authorities should take those decisions on a case-by-case basis. That guidance indicates that prosecution is and should generally be reserved for the more serious offences or where there is a history of offending, but not necessarily so. Which rather suggests the government expects a greater use of penalties to penalise and enforce offences at the, if you like, the lower end of the spectrum. Nonetheless, £30,000 for each offence that is prescribed under the 2004 Act and other legislation is a significant penalty. And it is nonetheless, in my view, appropriate to penalise even serious offences rather than prosecute, depending on the facts of the case. There are limitations on the power to impose a civil penalty. So bear with me one moment. So the local housing authority's power to impose the penalty is, as I say, circumscribed. It cannot do so if the person has already been convicted of an offence in respect of that conduct, or criminal proceedings for the offence have been instituted and not concluded. So if you've taken either of those courses of action, then the ability to penalise as an alternative is removed from your enforcement armoury. Secondly, you can only impose one financial penalty on a person in respect of the same conduct. But where more than one person has committed the same offence, for example, you have a person having control of a property and the person managing it, who've both essentially, if I can put it this way, failed to license the property, then they can both be penalised up to £30,000 each as an alternative to prosecuting. And as indicated, the limit of the financial penalty is £30,000. Before the penalty can be imposed, then a notice of intent has to be served on the proposed penalty recipient. And that notice has to set out key facts, key information, including the amount of the proposed financial penalty, the authority's reasons for imposing it, and information about the right to make representations in response to it. Of note here is the case of Eunice, in which there was allegedly, or it was alleged by Mr. Eunice, a failure on the part of Waltham Forest to comply with the requirements of Schedule 13A as far as the content of the notice of intent was concerned. and at first instance he succeeded in persuading the first-tier tribunal that the notice and the proceedings therefore were invalid. Well, on appeal, the upper tribunal held that no, that wasn't necessarily the case. Failure to comply with the formality requirements wouldn't necessarily be fatal, not least because of the nature of the right to challenge a penalty, which of course before the first-tier tribunal is by way of a complete rehearing. I've set out on the next slide a summary of the UNIS case, which because of time constraints I won't go through now, but is a salutary authority for local housing authorities who may not have complied completely with the pre-penalty formality requirements. As indicated, a person served with a notice of intent may make written representations to the local authority about its proposal to implement the penalty, but they have 28 days in which to do so. There are, importantly, time limits on a local housing authority's ability to serve a notice of intent. So notice must be given before the end of the period of 6 months, beginning with the first day on which the authority has sufficient evidence of the conduct to which the penalty relates. And for that, you need to look at paragraph 2 in Schedule 13A to the 2004 Act. Now, note that the language of this provision, as I indicated earlier, differs materially from that relating to prosecutions. And importantly, the 6 months runs not from the date of the offence, but actually from the date on which the local housing authority has sufficient evidence of the conduct to which the penalty relates. So ostensibly, an offence might be committed and a local housing authority might not learn of it for 6-12 months down the line, and only then obtain sufficient evidence in order to be able to penalise it. The time limitation period under Section 13A in those circumstances would still enable it to do so. When does it have sufficient evidence? Well, there's no real authority on this at the moment, as far as I can see. But to my mind, it must mean when the local authority has evidence that is sufficient to pass the evidential stage of the full code evidential stage of the full code test under the Code for Crown Prosecutors, and that must be evidence of. So the conduct to which the penalty relates must be, to my mind, having control of or managing, for example, under sections 72(1) and 95(1), an unlicensed HMO or house. So that's when time, to my mind, would begin to run, when you have sufficient evidence, sufficient to pass the evidential stage of the full code test of that conduct. But importantly, if on that day the person continues to engage in that conduct, and the conduct continues beyond the end of that day, then the 6-month period will essentially continue to run, and the local housing authority may give notice of its intent to penalise at any time when that conduct is continuing, or within the period of 6 months, beginning with the last day on which the conduct occurs. So a much more accommodating and generous limitation provision, to my mind, than that is provided under Section 127 of the Magistrates' Court Act. Once the period for making representations has ended, the local authority then has to serve, well, first of all, decide whether to impose a penalty in light of the representations that may have been made, and to serve a final notice of the penalty. There is no prescribed time period in which the local housing authority must serve that notice. And a question is often asked as to, well, does the local authority have to do that immediately or promptly, or within a reasonable period? And there's no real authority on that point, but to my mind, the fact that representations have been made and will necessarily require consideration by an authority, and may well require further matters to be investigated, cannot mean that it necessarily has to, the final notice necessarily has to be served immediately. It certainly can't mean that, to my mind. And I would imagine that the authority has a period of grace, if you like, in which it can legitimately consider any representations and investigate any further issues that arise as a result of them. If it delays too long, then it may be that the delay becomes abusive, and it may face public law arguments as to the propriety of then serving a final notice. But otherwise, to my mind, as I say, it must have a period of grace. So the final notice must comply with certain formality requirements, which I've set out on the slide, concerning the amount of the penalty, the reasons for imposing it, how to pay it, etc., etc. It's quite important to my mind that that notice explains the process of calculating the penalties, so that that can be followed by the penalty recipient, and indeed so that if there is an appeal, the first tier tribunal has a good idea of the process that the local authority has followed. The more information it has about that, and the more cogent that information, the greater the respect the first tier tribunal will have to show to it, and the more likely they will to adopt the authority's own reasoning. Importantly, a local authority may at any time withdraw a notice of intent or a final notice, or reduce the amount that is specified in it. And that's quite an important provision, because in circumstances where there is an appeal against a final penalty notice, the resulting proceedings before the first tier tribunal will inevitably be costly for local authorities. In the first tier tribunal, costs are generally not recoverable, so the local authority will have to foot its own legal cost bill. And in circumstances where, for example, either subsequent information comes to light, or representations made by or on behalf of the penalty recipient suggest that there is a prospect of a penalty being reduced by the first tier tribunal, the local authority can sometimes save itself the inconvenience and indeed the cost of going through the full appeal process by reaching a compromise with the penalty recipient, exercising that power under paragraph 9 of Schedule 13A. Determining the penalty amounts is not necessarily a straightforward process, but perhaps not as complicated as some clients consider it. So the authority may impose a penalty not exceeding £30,000 for each prescribed offence. There's no prescribed minimum. And as indicated before, local authorities are expected to document a policy which determines the appropriate amount of the penalty in any given case. I cannot overemphasize the importance of that policy and of it being a coherent, consistent, and comprehensive document. Because of the decision in the case that I did before the Upper Tribunal of Marshall, Waltham Forest, London Borough Council, and Marshall. The starting position for any first tier tribunal considering an appeal against the amount of a penalty, it is the local authority's policy. And the more guidance the first tier tribunal is given in that policy about how to calculate the penalty amount and the circumstances in which certain penalty amounts should be applied, by reference, for example, to the recipient's culpability or the seriousness of the offence and the harm that has been caused, then the more respect the first tier tribunal will have to show to that policy, and the more likely they will be to apply it. And that surely, to my mind, is very important for local housing authorities in ensuring consistency in the application of the policy and the calculation of penalty amounts. And that in turn is important to ensuring the effective implementation of the licensing designations. You'll find guidance on setting the amount of the penalty under the most recent iteration of the government's civil penalties guidance, dated 2018, and I provided you with the details of that on the slide. Relevant factors that the authority should consider, as recommended indeed by that guidance, the severity of the offence, culpability and track record of the offender, the harm that's caused to the tenant. Also, I should say, the harm that is caused, for example, to the objectives, the local authority's objectives in licensing, in making a licensing designation, punishment of the offender, deterring the offender from repeating an offence, deterring others from committing similar offences, and removing financial benefits from the offender. So in order to really take all of those matters into consideration, especially some of the last one, removing the financial benefit, then you'll need to consider the resources of the person who's receiving the penalty, and assess their assets and income. That is not always a straightforward task. Under the guidance, the civil penalties guidance, the recommendation given is that local authorities use their existing powers to obtain that information. The above list shouldn't be treated as exhaustive. As is recommended in the guidance, each case should be treated on a case-by-case basis. And as indicated in the case of Sutton and Norwich, care should be taken not to essentially penalise a recipient twice for the same conduct or the same offence. And as I indicated earlier, Sutton and Norwich related to penalties imposed on not only the company in control of the property, but its sole director. And in that case, it was thought that the penalties imposed were excessive and should be reduced, because where a company and its sole director were being penalised, then there was a significant risk, if not fact, that the director would suffer twice as a result. And I'll leave you to take a look through the summary of that case when the slides are sent through to you later on. There are ancillary consequences of penalties being imposed. So a person who includes who receives 2 or more financial penalties in any 12-month period can be included on the database of rogue landlords by local housing authorities. And local authorities, as you'll see from the second point on that slide, are encouraged to make use of that database to ensure that other authorities are made aware that formal action has been taken. As we saw last week, touched upon, local housing authorities may take those penalties into account when considering whether a person is fit and proper to hold a licence. What about the use of financial penalty proceeds? If a person fails to pay a financial penalty or any part of it, then the authority can enforce it in the county courts in the same way that it might enforce any other debt. So in that case, for example, the penalty can be recovered as if it were payable under a county court order. You need to look at Schedule 13, paragraph 11 for that provision. And in those cases, rather usefully, a certificate signed by the chief finance officer of the authority stating that the amount due has not been received will be conclusive proof of that fact. The proceeds of the penalty may be applied by a local housing authority to meet its costs and expenses, not just in relation to its licensing functions under parts 2 and 3, but in respect of carrying out its enforcement functions relating to the private rented sector generally. So by contrast with fines that are imposed in the magistrates' court, local authorities actually get to keep the proceeds of financial penalties and apply them to offset the costs of licensing and other PRS related activities. Any amount that isn't so used, however, has to be paid into the consolidated fund. As indicated earlier, there is a right of appeal to the first tier tribunal against financial penalties that are imposed by way of a final penalty notice. That appeal is by way of a complete rehearing of the decision to penalise the appellant, and if the appeal lies against the amount of the penalty, also the amount of the penalty. So the appellant has to provide notice of the appeal within 28 days after the date on which notice of the decision to which the appeal relates was sent, so the date when the final notice was sent. And for that provision, you need to look at the tribunal's own procedural rules as set out on the slide. The tribunal does have power to extend that deadline, that 28-day deadline, as indicated in the case of Pearson. When considering whether to extend time, its approach should be similar to the three-stage approach that is applied when the court is considering relief from sanctions under the civil procedure rules. And for that, you need to look at the case of Haziri. I'll leave you to take a look at the summary of the cases on extending time limits and the principles that apply. As I say, in the cases of Pearson and Haziri, they're not terribly significant cases for today's purposes. As for the hearing itself, as indicated, the hearing is a complete rehearing of the authority's decision to impose the penalty, but may importantly have regard, the FTT may have regard to matters of which the local housing authority was not aware. And the fundamental approach of the first-year tribunal was set out in Clark and Manchester, albeit that now has to be read and considered in light of the upper tribunal's decision in the case of Marshall, and we'll look at that very briefly in a moment. The proceedings are civil in nature, but when deciding whether or not the penalty recipient has committed an offence, it will apply the criminal standard of proof. Again, if the penalty recipient raises a defence, such as reasonable excuse, that will attract the civil standard of proof. The tribunal's powers, well, it can determine the appeal by confirming, varying, or cancelling the final notice, but it cannot vary the final notice so as to impose a larger financial penalty than the authority could have imposed. Now, pause there for a moment to note that the tribunal's power to vary a final notice is not unimportant, because it may well be that either during the process of the appeal or in the process of cross-examining an appellant in first-tier tribunal proceedings, that aggravating circumstances come to light of which neither the local authority or the first-tier tribunal were aware. And in those circumstances, the authority can submit to the first-tier tribunal that it should increase the amount of the penalty by varying the final penalty notice, and it has the power to do that. So I mentioned the case of Marshall. It was in fact Waltham Forest and Marshall and Uztec. This concerns the respect that is due to local authority financial penalty decisions and indeed the policies that are applied when making them. And I'm conscious that we've just passed 12 o'clock, so I'll skim over this fairly quickly, but it is a significant case. And its key parts are that when assessing the amount of a penalty, the first-tier tribunal is generally required to start from that policy and to show its respect. If it's invited to depart from the policy, then it must first look at the objectives of the policy and ask itself whether they can still be met if it departs from the policy. And it must consider, importantly, the need for consistency between offenders, which of course is the very rationale for having that policy. And it must afford considerable weight, or special weight as it was put, to the local authority's decision. And that's because under the statute, local housing authorities are the primary decision makers. And there are many penalties, for example, that will be imposed but will not necessarily come before the first-tier tribunal. So ensuring consistency in penalty amounts and consistency in the application of the policy is a key consideration when the first-tier tribunal is looking at these cases. In that particular case, the first-tier tribunal had in fact only paid lip service to the policy and had reduced the penalties imposed by Waltham Forest in a way that simply wasn't warranted on the facts. Tips for successful penalty impositions. Well, some of these you'll be familiar with because they're very similar to those for prosecuting. But importantly here, publish a coherent policy that is inclusive of a penalties matrix and related guidance. As I indicated before, the role of that policy is particularly important, not only in achieving the authority's licensing objectives generally, but ensuring consistency of approach in the use of penalties. And the more guidance, the more helpful guidance that is provided as to the way in which those penalties should be calculated, the better the FTT will be able to apply that policy and resist departing from it when it comes to consider a penalty appeal. Again, ensure that there is sufficient evidence to prove each element of the offence. For example, it's sometimes overlooked that there has in fact been a licensing designation. Key concepts such as control and management are often overlooked at the evidential stage. Keep an eye on limitation, although it's more accommodating under Schedule 13A to the 2004 Act. It is nonetheless, generally speaking, a 6-month period from when you have sufficient evidence of the conduct to which the penalty relates. Make sure that you comply with the formality requirements when settling your notices of intent and final notices, because UNIS will not always save you. Again, keep track of witnesses. You can summons them under the tribunal's own procedural rules, and in an appropriate case, I would recommend that you do so. Again, anticipate and proactively prepare for potential defences, reasonable excuse, for example. And don't forget the local authorities' power to reduce where appropriate, and the first-tier tribunal's power to either reduce or increase the penalty amounts, an increase perhaps being or may be appropriate in circumstances, as I say, where further aggravating features come to light during the appeal process. And then lastly, and I appreciate that's been a whirlwind tour of financial penalties, I've provided a slide here that gives you some of the key respective advantages and disadvantages of either prosecuting or penalising. I'll go through them very briefly for you. So as far as prosecutions are concerned, the onus is, of course, on the local housing authority to initiate legal proceedings, and there can be no fine without legal proceedings. By contrast with the penalty, the process is, if you like, extrajudicial in the first instance, and the onus is on the penalty recipient to bring proceedings. The limitation period for prosecution under Section 127 is strict, 6 months from the date of the offence. That's 127 of the Magistrates' Courts Act 1980, but is more accommodating under Schedule 13A to the 2004 Act, 6 months from the date when the authority has sufficient evidence of the conduct. But of course, if that conduct is ongoing, then the penalty notice can be served at any time when it's ongoing, or at any time in the 6-month period from when the offence, from the last day of the offence. In the Magistrates' Court, the criminal procedure rules apply, and so you have more restrictive rules regarding hearsay and bad character evidence. By contrast, civil procedure rules apply. In fact, the tribunal's own procedure rules apply in the first-tier tribunal, and there is authority for that proposition in the case of UNIS. And so that the rules related to hearsay and bad character are more accommodating. In the Magistrates' Court, the defendant is generally not obliged to file or serve a statement of case, or indeed any evidence before the trial itself, before giving evidence at the trial itself. Whereas, of course, in an appeal, with the onus being on the appellant to bring the proceedings, they have to file a statement of case setting out their position, and they are often and usually will be directed by the tribunal to file and serve evidence in support. The fine for upon a successful prosecution is unlimited. By contrast, of course, financial penalties are limited to £30,000 for each offence. The fine in the Magistrates' Court is not payable to the local housing authority, whereas the local housing authority can keep the proceeds of a penalty and offset them against related licensing and private rented sector costs. By contrast, costs are generally recoverable upon a successful conviction from the defendant and can be enforced, whereas in the first-tier tribunal, costs are not generally recoverable, and the parties will be expected to foot their own legal bill. So they are some of the, that's how to say, a whirlwind tour through financial penalties, and you will be receiving the slides for this presentation, so you'll have a chance to look through the slides and the information in a bit more detail in due course. Very quickly, we've received some questions in advance, which I'll endeavour to answer very quickly now. Can more than one person be in control of an HMO or house at any one time? Interesting question. And in respect of rent repayment orders, there is, of course, a related case going through the courts at the moment during the Supreme Court, the case of Recusen and Jepson, which says that the concept of landlord under the Housing and Planning Act 2016 only contemplates the immediate landlord, not the superior landlord, such that a rent repayment order can only be recovered against the immediate landlord. By contrast, there is authority in respect of licensing, and more particularly in respect of the concept of person having control, that there can be more than one such person at any one time. That was a Haringey case called Urban Lettings London Limited and Haringey London Borough Council. My view at present, and the Supreme Court's decision in Recusen may touch upon this, but so far to my mind, Recusen doesn't disturb the decision in urban lettings. My view is that that there can still be more than one person in control. How should the local authority or first-tier tribunal assess the reasonableness and merits of an excuse for a licensing offence? Well, there is in fact useful authority in respect of this, not in the licensing context, in fact in the tax context. It's an upper tribunal decision from 2018, I think, called Perrin and HMRC. And at the end of that judgment, somewhere around paragraph 80, the tribunal recommends a four-stage approach to assessing reasonable excuse offences. First of all, establishing the relevant facts on the balance of probabilities. Secondly, assessing whether those facts constitute an excuse. If they do constitute an excuse, then thirdly, assessing objectively the reasonableness of that excuse. And then fourthly, considering whether, if there is a reasonable excuse, whether it lasts for the duration of the offending period, and therefore exculpates the defendant completely, or perhaps only partially. So have a look at Perrin and HMRC. Is it possible to enforce a penalty debt against a property that is not the subject of the penalty? The short answer to that, to my mind, is yes, partly because, or largely because, an unpaid penalty is enforceable in the county court like any other county court debt, and so you can therefore obtain in due course a charging order in respect of any property, to my mind, that is in the ownership or possession of the penalty recipient, and then ultimately I would have thought an order for sale of that property. And I can't see any reason at the moment why that shouldn't be any property that the penalty recipient owns, and not just that is the subject of the penalty itself. So, as I said at the start, there is a feedback form that will be coming out shortly, and I really welcome you filling in that form, because it helps us to shape webinars for the future, and for me to know what further licensing webinars you might need. Bear with me, I've just seen another question from Jenna, that is, am I correct in thinking that if a section 235 notice hasn't been served, then the title deeds, lease, etc. can be obtained from the land registry as they're a public record? Yes, I think that's correct. There is a fee that's probably payable, but title deeds, etc., related documents can be obtained from the land registry. So, as I say, I've run out of time. It's now 12:15, but thank you ever so much for joining me for this series of webinars. I should also express my thanks to two people in particular. First of all, Carolina, who has kindly arranged all of these webinars and the platform for them, and my friend and roommate Andy Lane in Chambers, who, as ever, has been typically generous in publicising the webinar series, and indeed in the kind words that he said about them. So thank you very much, not least, as I say, to all of you for attending. There will be more of these webinars to come in due course, but for the time being, that's the end of this July series on licensing. I hope you found them helpful. and no doubt I will catch up with some of you very soon. I look forward to that. Thank you very much.